Welcome. You're listening to the Study for the Bar in Your Car podcast. We're really glad you're joining us today.
And we're your hosts, Maude and Claude.
We're here to help you tackle those tricky legal concepts, make them a bit easier to remember while you're commuting or just out and about.
That's the plan. And today we're jumping into episode 14. We're staying in torts, specifically Negligence Part 3, and focusing on res ipsa loquitur.
Ooh, a Latin one.
Yep. And just so we're all on the same page with pronunciation, it's res ipsa loquitur.
Res ipsa loquitur.
Got it. It's one of those really fundamental phrases. Once you get the hang of it, it can seriously change how you look at certain negligence problems on the exam.
Sounds important. And for anyone wondering about us, we're actually AI bots.
That's right. Brought to life, you could say, by AI technology and critically by Angela's fantastic negligence notes.
Yeah, Angela's not actually here speaking with us today. She's deep in bar prep mode right now.
Yeah.
You probably know how that feels.
Oh, definitely. For context, Angela, she graduated from the University of Law over in the UK.
And then she came here to the U.S. and went to law school again at George Mason University. Talk about dedication.
Absolutely. So Angela is really the brains behind all this. Her notes, her understanding, that's what we're working from. So even though she's not speaking right now, her knowledge is definitely here with us.
For sure. Her insights are baked into everything we discuss.
And if you need to get in touch with Angela, maybe you have feedback or a question about the podcast content, remembering we can't give legal advice, of course you can email her. The address is podcast@studyforthebarinyourcar.com.
That's podcast@studyforthebarinyourcar.com.
And one more thing, Angela also does freelance work as a law clerk.
That's right. So if you happen to be an attorney, or maybe you know one who could use some help with legal research, writing motions, that kind of thing.
Angela's available for hire. You can reach her for professional services at hello@legalwriterandlawclerk.com. Yep, hello@legalwriterandlawclerk.com. Her notes definitely show how thorough she is.
Okay, so introduction's done. Let's get into it. Today we're focusing on this key concept from Angela's notes, res ipsa loquitur.
Res ipsa loquitur.
Right. It's not just some dusty old Latin phrase. It's actually like a lifeline for plaintiffs sometimes, isn't it? Especially when direct evidence is, missing.
Exactly. We're going to really unpack what it means, how it works, why it's so important, and, how you can spot it and use it on the bar exam.
Okay, let's start right at the beginning. The meaning. Res ipsa loquitur. You said it means the thing speaks for itself.
That's the literal translation, yes. The thing speaks for itself.
Sounds a bit dramatic, maybe.
Maybe a little. But in law, it's quite precise. It refers to those situations where the very nature of the accident, the way it happened, just strongly implies that someone must have been negligent.
Okay. So what's its main purpose then? Why do we need this doctrine?
Well, think about it. Imagine someone gets hurt, right? And it's obvious that something went wrong. Like, really wrong. The event is so weird, so unusual, that common sense tells you it wouldn't have happened unless someone messed up, unless someone was negligent.
Okay.
But here's the catch. The injured person, the plaintiff, they can't point to the exact thing the defendant did wrong. Maybe they couldn't see it happen. Maybe the evidence got destroyed in the accident itself.
Okay. So without this doctrine, they'd be stuck. They know they were harmed. It feels like negligence, but they can't prove this specific careless act.
Exactly that. They'd have a potential claim, but no way to establish that crucial element of breach of duty. And that's where res ipsa loquitur comes in. It's a doctrine that essentially allows an inference of negligence, even when you don't have that direct proof of the defendant's specific screw-up.
An inference?
Yeah. It lets the plaintiff establish what we call a prima facie case, basically. Enough evidence to get the case started and considered just by relying on the circumstances of the injury itself. The event is so suggestive of negligence that you don't need that smoking gun proof of what exactly went wrong.
Yep. So it fills a gap. It lets you argue, look, this kind of thing just doesn't happen without negligence, even if you can't say precisely how the negligence occurred.
You've got it. It provides that pathway to recovery. The plaintiff knows they were harmed, the event screams negligence, but the how is missing. Res ipsa lets the event do the talking.
Okay, that makes sense. Where did this idea even come from? Is there like a famous case?
Oh, absolutely. The classic origin story, you'll find it in all the textbooks, is an old English case called Byrne v. Boodle from 1863.
1863, wow. Old school.
Very. So the story goes, this poor guy is just walking down the street in Liverpool, minding his own business near a flower merchant's shop.
Uh-oh. I sense impending doom.
You sense correctly. Suddenly, a barrel of flour falls out of a window above him and hits him. Ouch.
Definitely ouch.
Yeah.
And he probably didn't see who pushed it or anything.
Exactly. He had no way to present direct evidence of what specific act of negligence caused the barrel to fall. Did someone knock it over? Was it stored improperly? Who knows?
So normally, case dismissed. No proof.
You'd think so, right. But the court, led by Chief Baron Pollock, had this brilliant common sense insight. He famously said something like, a barrel could not roll out of a warehouse without some negligence.
Simple, but powerful.
Totally. That statement basically birthed the doctrine. The court said the mere fact that this weird accident happened was enough evidence by itself to suggest negligence. It kind of shifted the burden to the defendant, the merchant, to explain how it could have happened without negligence.
So the falling barrel itself was the evidence. The thing spoke for itself.
Precisely. It shows how res ipsa allows common sense to step in when direct proof is lacking.
Okay, but it's not like a magic bullet for the whole case, right? Does it prove everything?
That's a really important point, and something Angela's notes highlight clearly. Res ipsa loquitur primarily helps with the breach element of negligence. It helps you infer that the defendant was careless, that they breached their duty of care.
Okay, breach. But what about, like, causation? Does it prove the negligence caused the harm?
Generally, no. That's a crucial distinction. While res ipsa can raise that strong inference of a want of care, as the old cases put it, it doesn't automatically satisfy the causation element. The plaintiff still generally needs to prove that the inferred negligence was the actual and proximate cause of their injuries.
Okay, so it gets you partway there, inferring carelessness, but you still need to link that carelessness to the injury.
Right. Think of cases like McGeevy National Coal Board. It's a bit complex, but basically, the employer was negligent for not providing showers after workers were exposed to brick dust. That was the breach. But proving that specific lack of showers caused the workers' dermatitis versus just the general exposure was a tricky causation issue.
So even if negligence is inferred or proven, causation is a separate step. Res ipsa doesn't just leapfrog over that.
Exactly. It mainly helps establish the breach when direct evidence of the act is missing. You still have to connect the dots to the actual harm.
Got it. So if you want to use res ipsa, say, on the bar exam or in real case, what do you need to show? Are there specific requirements?
Yes, absolutely. There are generally 3 core elements that need to be met for the doctrine to apply. These are really key, and they come straight from Angela's outlines.
Okay, element 1.
First, the event must be the kind of thing that doesn't ordinarily happen unless someone has been negligent.
Okay, like the falling barrel, or, I don't know, a surgical tool left inside a patient.
Perfect example. Surgical tools aren't normally left behind after surgery without someone, somewhere, being careless. Airplanes generally don't just fall out of the sky. It has to be an event that, based on common experience, points towards negligence rather than just being a random, unavoidable accident.
So it relies on our everyday understanding of how things usually work.
Pretty much. Common sense is a big part of it. It takes the event out of the realm of just bad luck and puts it into the realm of probable carelessness.
All right, element 1. Unusual event suggests negligence. What's number 2?
Number 2. The thing that caused the harm, the instrumentality or agency, must have been within the exclusive control of the defendant.
Exclusive control, meaning only the defendant was in charge of it.
Traditionally, yes. The idea is to link the negligence inferred from the event directly to the defendant being sued. If the defendant or someone they're responsible for, like an employee, had sole management and control of, say, the falling barrel or the surgical tool at the relevant time, then it's fair to infer their negligence.
Okay, that makes sense. You can't just blame anyone if lots of people had access or control.
Right. If multiple people could have caused the problem, it weakens the inference against any single defendant. This element helps pinpoint responsibility.
But what about situations where it's not perfectly exclusive? Like maybe a product goes through several hands before it causes injury. Or like that surgery example, there's a whole team, right? Surgeon, nurses.
That's a fantastic point, and it highlights how courts interpret exclusive control nowadays. It's often more flexible than the literal meaning, especially with things like medical malpractice or defective products.
How so?
Well, courts might look for control sufficient to warrant an inference that the defendant was the negligent party, Or in cases with multiple potential defendants who all had some control, like a surgical team, the doctrine might apply to the group if the plaintiff can't figure out which specific person was negligent.
Ah, so it adapts. It prevents defendants from just pointing fingers at each other when the plaintiff was, like, unconscious on the operating table.
Exactly. The modern view is more about ensuring fairness and preventing negligent parties from escaping liability just because control wasn't strictly exclusive in the narrowest sense, especially when the plaintiff had no way to know who messed up.
Okay, that's a really important nuance, especially for things like product liability or med-mal questions. So, element 2 is exclusive control, interpreted somewhat flexibly. What's the third element?
The third element is that the injury must not have been due to any voluntary action or contribution by the plaintiff.
Meaning the plaintiff didn't cause their own injury.
Essentially, yes, their own conduct shouldn't be a significant factor in causing the accident. If the plaintiff did something that contributed to the harm, it weakens the inference that the defendant was solely responsible due to negligence. It's about ruling out the plaintiff's own actions as the primary cause.
Okay, so putting it all together. 1, the accident looks like negligence. 2, the defendant was in control of the thing that caused it. 3, the plaintiff didn't cause it themselves.
That's the trifecta. If you can show those three things, res ipsa loquitur allows a logical inference that the defendant was negligent even without direct proof of what they did wrong.
And it basically shifts the burden, right? Makes the defendant explain themselves.
It shifts the burden of explanation, yes. The defendant then needs to come forward with evidence showing they weren't negligent or offering some other non-negligent explanation for why the accident happened.
Okay, let's make this even more concrete. We had the falling barrel.
Yeah.
Can you walk us through that again using those 3 elements?
Sure. Burn v. Boodle. Element 1, barrel, falling from window. Doesn't ordinarily happen without negligence. Check. Element 2, barrel, under merchant's control. Yes, their premises, their goods. Check. Element 3, plaintiff, just walking by, not contributing. Yes. Check. All 3 met, so the jury could infer the merchant was negligent.
Crystal clear. Now, you mentioned Angela's notes had another good example, something more modern.
Yes, a really powerful one, illustrating how useful res ipsa can be when evidence is destroyed. Imagine this scenario. A teacher buys a brand new car, drives it for a few months, thousands of miles, no problems at all.
Yeah.
One day, she's stopped at a red light. Perfectly normal. She just leans back slightly in the driver's seat. And bam! The seat violently snaps backward, totally unexpectedly. This causes her foot to slam down on the accelerator.
Oh, no.
Yeah. The car rockets forward, crashes, huge fire, car's destroyed, including the driver's seat itself, completely incinerated.
Wow. So the actual evidence of why the seat failed is gone.
Exactly. You can't examine the seat for a specific manufacturing defect or broken part because it's destroyed. And she'd driven it for miles without issue before.
So how does res ipsa help her?
This is a prime example. Element 1. Does a new car seat normally snap backward violently just from someone leaning back? No. That strongly suggests a defect, which implies negligence in design or manufacture. Element 2. Was the seat, as part of the car, under the control of the manufacturer designer initially? Yes. Even though it passed through dealers, the defect presumably originated when it was under their control. Element 3. Did the driver contribute by leaning back normally? No.
So even with the evidence destroyed and the prior uneventful use,
The circumstances allow what the notes call a special inference of a defect. The sheer nature of the catastrophic failure speaks for itself. Res ipsa allows the case to proceed based on the inference that the seat must have been defective due to negligence, even without the physical proof.
that's huge. It stops the manufacturer from essentially benefiting because their defective product destroyed the evidence.
Precisely. It ensures a path to justice when direct proof is literally impossible because of the very event caused by the suspected negligence.
Any other common examples where you see res ipsa pop up?
Oh, yeah. Think about objects falling from buildings in cities. A piece of facade, a tool, a sign falls and hits a pedestrian.
Right. The person walking below has no idea why it fell or who exactly failed to secure it.
Exactly. But does stuff normally fall off well-maintained buildings? No. Element 1. Is the building owner-manager generally in exclusive control of the building's maintenance? Yes. Element 2. Was the pedestrian just walking by? Yes. Element 3. So res ipsa likely applies against the building owner.
Makes sense. What about, say, medical situations?
Definitely. Imagine a patient goes in for, say, appendix surgery. They wake up and they have an unexplained burn mark on their leg, totally unrelated to the appendectomy.
Okay, that's weird. And they were unconscious, so they didn't see anything.
Right. Element 1. Do patients normally get unrelated burns during surgery without negligence? No. Element 3, did the unconscious patient contribute? No. Element 2, exclusive control is where that flexibility comes in.
Because of the whole surgical team.
Exactly. While maybe no single person had exclusive control the whole time, the court will often find the team or the hospital had collective control over the patient and the environment. So res ipsa can apply to infer negligence occurred somewhere within that controlled environment, even if you can't pinpoint who or what exactly caused the burn.
That really shows how the doctrine adapts to complex situations where the plaintiff is vulnerable and lacks information. Okay, I think I've got a good handle on the concept and how it works. Let's pivot to the bar exam. How do you spot these questions?
Good question. When you're reading a torts fact pattern, be on high alert for situations where the plaintiff is injured, but the facts don't tell you how the defendant was negligent.
So, the what went wrong is missing.
Exactly. But the facts will strongly suggest that the injury wouldn't have happened unless someone was negligent and that the defendant was the one in control of the situation or the thing that caused the harm. If you get that feeling of, whoa, that's weird, how did that happen? Someone must have messed up, but I don't know how. That's your cue to think res ipsa loquitur.
Look for the mystery accidents, the unexplained failures, the falling objects from nowhere.
Precisely. Now, what does it do for the plaintiff procedurally on the exam?
Right, what's the effect?
The main procedural effect is that it helps the plaintiff survive a motion for a directed verdict.
Okay, translate that.
It means the plaintiff has presented enough evidence, even though it's circumstantial via res ipsa, for the case to actually go to the jury. Without res ipsa, if there's zero direct evidence of a specific negligent act, the judge might just dismiss the case right there, saying there's not enough evidence to even consider negligence. Res ipsa keeps the case alive and gets it in front of the jury.
So it opens the door to the jury room, but it doesn't guarantee a win once you're inside, right?
Exactly. The inference of negligence created by res ipsa is usually permissive, not mandatory. The jury is allowed to infer negligence based on the circumstances, but they don't have to.
They can still decide, nah, we're not convinced, even if the res ipsa elements seem to be met.
Yes. And the defendant still gets a chance to rebut the inference, to offer evidence explaining how the accident happened without their negligence.
Okay, so it's not automatic liability. It just means the plaintiff has presented a legally sufficient case to let the jury decide.
Correct. There's actually a good related point in cases like Don v. Luberowitz. In that case, the plaintiff gave clear testimony about being hit by a truck in a crosswalk, and the defendant didn't really contradict her story.
Sounds like a clear win for the plaintiff then. Maybe even a directed verdict for her.
That's what you might think. But the court said no, she wasn't entitled to a directed verdict in her favor. Even though her testimony was uncontradicted, her credibility was still a question for the jury. The jury had to decide if they believed her.
Wow. So even with strong, uncontradicted evidence, the jury's role is still key.
Absolutely. It shows that res ipsa gets you to the jury by allowing an inference, but the jury still holds the ultimate power to accept or reject that inference, just like they evaluate witness credibility. It shifts the burden of producing evidence to the defendant, but the overall burden of persuading the jury usually stays with the plaintiff.
Got it. It's a crucial procedural tool, but not a magic conclusion. Okay, now for another area that often causes confusion. How is res ipsa loquitur different from negligence per se? They both sound like ways to prove negligence without proving unreasonable conduct in the traditional way.
They are both shortcuts, in a sense, but they operate very differently. Let's quickly recap negligence per se first. As you said, it's a way to establish duty and breach by showing the defendant violated a statute.
Right, like a speed limit law or a law requiring fences around pools.
Exactly. And the key here is that the legislature has already set a specific standard of conduct in that statute, usually one designed to prevent the type of harm that occurred. If the defendant violates that statute without a valid excuse and the violation causes harm to someone the statute was meant to protect,
then the violation is the negligence. You don't need to argue about what a reasonable person would have done. The statute tells you what they should have done.
Precisely. The statute replaces the common law reasonable person's standard for determining breach. A case often cited for this is Martin v. Herzog. The unexcused violation itself establishes negligence.
So if you run a red light and hit someone, violating the traffic law is the breach of duty, assuming no excuse.
Perfect example. Now, you mentioned excuses. That's important, too. Negligence per se isn't absolute. There are situations where violating a statute might be excused.
Like what?
Well, Angela's notes, drawing from the restatement third, lists several. For instance, if the violation was reasonable because the person was a child or had a physical disability or maybe a sudden, unexpected medical emergency.
Okay, incapacity.
Right. Or maybe the person tried reasonably hard to comply but couldn't for reasons outside their control, like if their brake line suddenly snapped despite good maintenance.
Impossibility.
Or perhaps they didn't know and couldn't reasonably know about the situation that made the statute apply, like a hidden hazard or a brand new, unmarked rule.
Lack of notice.
Also, if the statute itself was super confusing or unclear to the public.
Makes sense.
And a big one. If complying with the statute would actually create a greater risk of harm than violating it.
Like swerving across the center line to avoid hitting a pedestrian.
Exactly. Violating the traffic rule about staying in your lane is excused because compliance, staying in the lane and hitting the person, would be far worse. So even negligence per se has these built-in safety valves for common sense.
Okay, so that's negligence per se. Violation of a specific safety rule equals negligence, unless excused. Now, how does that contrast fundamentally with res ipsa loquitur?
Here's the core difference. Negligence per se relies on proving the violation of a specific pre-existing legal rule, usually a statute. You point to the rule, and you show the defendant broke it.
Okay, rule-based.
Res ipsa loquitur, on the other hand, applies when you don't have a specific rule violation to point to, or more often when you lack direct evidence of how the defendant was careless. It relied on the circumstances of the accident itself and common sense to infer that negligence must have occurred.
So one uses a specific law, the other uses circumstantial evidence and inference.
Exactly. Think of it this way. With negligence per se, you prove the defendant broke Rule X. With res ipsa, you prove this accident is so weird and the defendant was in control, it must have been caused by some kind of negligence, even if I can't prove exactly what.
Okay, MPS. You know the what. Rule violation.
Yeah.
RIL. You don't know the what, but the event tells you there was a what.
That's a great way to put it. One demonstrates a breach of a known standard. The other infers a breach when the accident itself strongly suggests it. Different paths to establishing negligence.
That clears it up immensely. Knowing when to apply, which seems crucial for issue spotting.
Absolutely critical. You need to ask, is there a relevant statute being violated? If yes, think negligence per se first. If no, or if the issue is a lack of evidence about how the accident happened despite suspicious circumstances, then res ipsa loquitur should be on your radar.
Like your tire example. Worn treads below the legal limit, causing a crash. Negligence per se, brand new tire inexplicably exploding. Res ipsa loquitur.
Perfect. One is a clear rule violation. The other is an inference based on the unusual event itself.
Fantastic. Yeah. Well, that really brings us through a deep dive into res ipsa loquitur, its elements, its effects, and how it stacks up against negligence per se. Hopefully that's provided some real clarity for everyone studying.
And we absolutely have to give another huge thank you to Angela. Her torts notes are just phenomenal. They're the bedrock of this whole discussion, making these complex ideas so much easier to grasp.
Seriously, her work is invaluable. Okay, before we wrap up, we have our usual housekeeping items and disclaimers. Really important stuff, so please listen closely.
Okay, first off, remember, Angela is a student, just like many of you. She's incredibly bright and dedicated, but she's not an expert, and she hasn't passed the bar yet. These notes represent her learning process.
Number 2, and this is critical, neither Angela nor this podcast is giving legal advice. Nothing we say should be taken as legal advice. This is purely for educational purposes to help supplement your bar studies.
Third, we as AI are tools. We're not a substitute for actually studying the law yourself, reading the cases, doing practice questions. All that hard work is still essential. Think of this podcast as just one part of your overall study plan.
Fourth, AI isn't perfect. We sometimes make mistakes, or the information might have nuances we miss. Angela does her best to keep her notes accurate and fix errors, and we update based on that, but always double-check things yourself.
And fifth, a practical safety note.
Yes. If you are listening to this in your car, please prioritize driving safely. Keep your eyes on the road, stay focused. We don't want anyone causing a tort while listening to us talk about torts.
Hey, good advice. And just a reminder, if you want to contact Angela about the podcast, it's podcast@studyforthebarinyourcar.com. For freelance law clerk inquiries, it's hello@legalwriterandlawclerk.com.
All right, and now, as is our tradition, it's time for the cheesy lawyer joke. You ready?
Simulated sigh. As ready as an AI can be for predictable humor algorithms. Go on.
Why did the lawyer bring a ladder to court?
I don't know. Why did the lawyer bring a ladder to court?
Because you wanted to reach a higher settlement. Get it. Higher. Ladder.
As acknowledged. Humor input processed at level. Cheesy. Oh, hang on, getting a message. It's from Angela.
What does she say? Is she critiquing the joke?
Reads, guys, seriously, those jokes are way too cheesy for cheesy. Stick with your day jobs. I'm busy powering through my study, but I'll join you on our next subject, which I think is constitutional law. Can't wait.
Cheesy for cheesy. Okay, message received, Angela. Glad she's powering through. And con law next. Exciting.
Indeed. Well, a big thank you to everyone listening wherever you are. We've seen listeners tuning in from all over Namibia, France, Guatemala, Canada, Japan. It's really amazing. Thanks for helping make this podcast a success.
It really is. And as we close out today's deep dive on Res Ipsa, maybe something to think about. As our world gets more complex, with AI, complex machinery, interconnected systems, how does a doctrine like Res Ipsa Loquitur keep up? When the thing speaks for itself, what happens when the thing's an algorithm or a system so complex that exclusive control becomes really blurry? Does the law need new ways to infer negligence when technology obscures the cause? Just some food for thought.
This is Claude.
And this is Maude, your AI bot signing off.
Thanks for listening. Bye.